Why don't you get your speaker so you can hear better? You have 10 minutes. Huh? Yes. Have you tried it? Okay. Check your Gmail to see if you sent a different code. Buddy? And she says anything to her that she started making plans for the kids.
Então, crescer nada.
I know. But on your week, she started making plans for the kids on your time.
Então, não quer dizer nada nisso.
Really.
Okay, we're back. First order proceeding today is I want to show you all the child dinner. So I'm going to share my screen and y'all are going to get a chance to read it. I'll give you about 5 minutes each page before I turn to the next one. If you get early, just let me know. Let's see here. Can y'all see that? Yes, John.
Yes.
Okay. I'm good here.
You can move forward.
All right. I'm right here.
I have a couple of questions.
Yes, go ahead, sir.
I want to clarify a couple of things that I haven't been given any information on or any response to in any kind of writing. For instance, who the plaintiff is to begin with.
The petition was filed with my mother.
It was filed by Rhonda Doe?
Yes.
Okay. Did she do so according to Title 5, Section 456.006B1 that requires her to do so with an affidavit?
Okay. Mr. Cochran, you want to address that?
Yes, Your Honor, my understanding is this is a modification case, and we are trying to modify a
Mr.
divorce decree from 2011.
Mr. Busham?
Let him respond.
Well, I have an issue with him speaking since he hasn't been sworn in, and everything he has to say is hearsay evidence.
He's stating his position, he is not actually sworn in.
Even though the knowledge that he has is hearsay.
It's in the name of our, it's not sworn. It's not a statement of
Thank you, Your Honor. Yes, as I was saying, it's a modification case of the order from, I believe, 2011 divorce decree, and I represent the investigating commissioner, Ron Doe, and we are here in court to try and make an argument as to what the best interest of the children currently, and we are asking for the court to make an order with respect to conservatorship, possession, and access to child support of the for temporary purposes today. And as to Mr. Olivas' suggesting that this isn't in line with whatever codes that she referring to, I would clearly be referring to Texas Family Code or some other statute regarding what the there's no close to modification of primary object with the I see. And Your Honor, with respect to that specific provision of the Family Code, if we are going to address the planning review today, we certainly have the ability and right to request that the court look at the possession and access schedule. We're not going to touch the issue of primary today, Your Honor.
I object to that for the very specific reason that I received paperwork and it said it was a temporary orders hearing, and specifically it mentioned that part of the Texas Family Code. Therefore, in regard to that code, it specifically talks about her having to do so in a form of an affidavit, or even if you want to go and further say, that it's not required. Well, Mr. Conacher was very, very helpful in saying that any kind of motion or petition or any kind of order that's before the court has to be done so as per Rule 47 with an affidavit as well. And there has to be some sort of appearance by the petitioner in the court in a way of an affidavit, regardless of which way you want to look at it. There cannot be a petition by hearsay evidence by an attorney who's got no first-hand knowledge on anything in regard to my sons or myself or any kind of anything. I've never met the man. I didn't have sexual relations with him. So he doesn't know anything about what this is entailing. Therefore, Rhonda has to have appeared before the court. Has she done so through the form of an affidavit of some sort, or even any kind of appearance officially? Because I've gone down to the records department and they have nothing. Well, the question for being, the question for me asking that is very specifically, the paperwork that I received said it was for temporary orders. And under temporary orders, it has to be for something that hasn't been done under a final order yet. In my case, or in this case, a final order has been issued, and she didn't file for an enforcement, and she didn't file for a contempt order under the final decree of divorce. So if she's filing outside of the final decree of divorce, then something that she's doing is obviously not in accordance with the final decree of divorce. And for the court to not enforce its own final orders is in contrary to its own rules.
What's really on is a lot of cases, probably what's going on the subject. Some issues are not planned, they primarily target
So, so are we following the Administrative Procedures Act, or what are we following exactly? Because I don't understand the rules here. The Texas Family Code, which falls under the Administrative Procedures Act, does it not? So it doesn't fall under the Texas Administrative Procedures Act. It doesn't fall under constitutional law. It doesn't fall under, what exactly are you falling under?
Okay, sir, we're not going to get into a conversation. I've made my ruling.
You've made a ruling?
I've made my ruling. You made a ruling objecting to his pleading. I'm partially sustaining that.
I object to that very specifically because under the provisions that you can rule under, you need a judge to sign off on any ruling or any recommendation by you in order for it to become an official order or ruling. It falls under the fact that there has to be a separation of any administrative procedure has to be separated under the Administrative Procedures Act, Section 5C. And it says that the functions are separated. So you yourself can't just order anything. You have to have a sign off on whatever it is that you recommend as an order by the Judge Kim Cooks. Well, if you're going to go under the Family Code, then under the Family Code, you have to be able to be ruling with no bias or impartiality. And under the way that the associate judge functions under the Family Code, you have a conflict of interest that should require you to completely and recuse yourself, which you have failed to do.
I have no conflict of interest. Your motion for use is already denied.
It was denied on a technicality, and none of the issues that I brought up was ever written about. And the judge that actually denied it, he himself failed to adhere to the procedure of 18A through 18B. He never gave anybody the notice of the hearing, and nobody was able to see what was ruled on or not. His ruling is
Another issue that's not before me, so we are proceeding at this time. You have 30 minutes. Do you have any new witnesses?
I don't have any new witnesses other than myself for attorney's fees, Your Honor.
Okay. Very well, then I'll take the parties that's under oath, as I previously before the end of the prior to August, I'm not going to keep that one. Mr. Conover, get the first, get the call, witnesses on your behalf. 30 minutes per side for questions, argument, and evidence testimony. So you may proceed, Mr. Conover.
Thank you, Your Honor. At this time, I move the introduction of P1 or summary request for leave of evidence. Any objection to P1?
I object to the fact that Mr. Conacher here is the one that's making all and putting in facts into the record because he doesn't have firsthand knowledge of anything. He shouldn't be able to be, putting any facts into the record. The person that's the one that's making the accusation should do that, and I have the right to examine that person.
Give me 1 moment, please. Was that from your email from yesterday, P1, summary of request for
I object. What part of this has to do with the original reason why the lawsuit was filed? If we're hearing evidence from the moment that the lawsuit was filed on forward, then we're not figuring out why the original lawsuit was filed. I haven't heard anything about why the cause of action for this lawsuit happened to begin with. On what grounds? Or give me a law that you're going off of, or you have to give a explanation of what law you're going off of, or what a fact that's before you to. So you're completely lawless then. Objection. That record is not fully given, and there's not a full record of what the text messages all entail. So you can't admit something that's partially, cut off from the rest. If it's not complete, then how is that evidence? Yeah, I object to the fact that this has nothing to do with the original reason why a lawsuit was followed, and has everything to do with, defamation of character at this point, and it's not even a complete recollection of the full transcript of messages. there's an objection to this because the the plaintiff has asked for me to work things out outside of court, and that's part of their petition. And every attempt that I have made in order to speak with either of them or any of them, which they have not reached out to me to figure out what's going on here, has been met with either a deliberate attempt at cutting off what I say or submitting it as evidence to defame what I'm trying to do. But I'm not the one that ordered the petition for figuring it out outside of court. They did, which is not exactly what they're doing. They're doing the complete opposite. Objection. That in itself is completely misleading because Rhonda Doe has actually called the cops on me and withheld my kids from me for no reason at all, and that's in violation of the divorce decree, and that was in my evidence from the first hearing, which I did submit and was allowed. So I even gave a proper notice to Rhonda Doe when she started doing that and withholding my kids. So the fact that you want to defame me and say that I was late for whatever doesn't constitute any sort of notice from Rhonda Doe as per the decree in regard to anything that happens to be an issue. Objection. They're not complete. Like I said, they are not complete. They are cut off at key points, and that was an attempt on my part, talking to her, to figure out what the resolution to this issue was, because to my knowledge, I had no idea she was even going to sue me, which is in contrary to the decree that she's supposed to be following. Objection. She didn't submit the full recording. She didn't submit the full recording, and therefore she cannot say that no modification was done. She definitely modified it, and she definitely cut it off at key points. So she cannot truthfully say that she did not modify it. I object to the simple matter that they're not complete, and that doesn't accurately represent everything that happened on those conversations. But that recording in itself showed how she's modified the recording and cut it off, even in the middle of her own words, to not hear the rebuttal after what she said. That's a modified recording, and it does not play out the full conversation of what was said. Objection. Objection. She's completely generalizing everything, whereas she herself has been in very serious violation of the decree, becoming even from where she lives and who she lives with, being a registered sex offender and not notifying the court or anyone else. So she's in a very, big violation of the divorce decree, and she cannot say that just simply a couple of modifications that we agreed on were or are going to modify the parent-child relationship just because she now feels that she wants to go after a financial thing where even that was agreed upon in the decree.
As far as the evidence, we have to go through, we testify to those witnesses. Your Honor, so I understand, I did move to admit the ingredient evidence for evidences. Okay. I'm going to share my screen again, Your Honor. I'm going to play what's marked with the date as E5 for the court. Your Honor, before I play that, please have the respondent's mic muted. I still think we're going to feedback from his audio.
I've been muting my microphone the whole time. I keep putting it on mute, and that doesn't make a difference. But I object to these recordings because they're all after the fact of the lawsuit that was filed. There's nothing before the lawsuit. Why are we looking at anything that's required? Anything that's dated after the lawsuit was filed. I still want to know what the cause of the lawsuit to begin with was, or what I did to exactly have this be an issue at this point. Again, you're noticing that these all recordings are cut off at very strategic points. I don't see how this is admissible evidence if she's not going to play the full thing. That none of these recordings are in succession from one another, and they're all incomplete. How is this evidence? Yeah, plenty of it. That was a 40. Well, the reason why I'm objecting to it is because this is incomplete. How is she only going to admit a part of the conversation when it was a 3 hour long attempt at trying to figure out what's going on and what to do about it? So I don't see how this is an admissible. I'm sorry, what? Objection. We've had plenty of communication via different means, and she was never not able to contact me. In fact, she did so several times through different means, but she always had my phone number, and she always had a way to communicate me if need be. There is no reason why she can say that she wasn't able to communicate with me. Objection. That's not a truthful statement. Objection. I wasn't not coming around. That's a false statement. Objection. He's trying to make it look like she has 100% of the expenses, and in reality, she does not, because every time they're with me, she never sends money this way. Therefore, anytime they're with me, she doesn't run the expenses, and that's the whole point of the final decree of divorce being no child support needed, because when they're with me, I pay for my expenses, and when they're with her, she pays for hers. So the whole conjecture of did he pay for that is obviously no, because that's the whole protection of the final decree of divorce. You have to share the children in order to share the expense. And she has been withholding the kids from me. That's the whole point I'm making. She's been withholding them from me.
Okay, again, not the nature of a legal objection, the nature of testimony, so that court can consider that to be an excuse. So it's not an objection to both. So, with that being said, are you and me leave us to sit to your child? Yes. And ma'am, did he text you in November last month, 2020? Yes. You see this on your screen now?
Objection again. She has cut off the communication between. That's not the full transcript of the text messages. It's not a complete transcript of it, and I don't see how this is relevant to the reason why the lawsuit was filed to begin with. No objections. I do agree with what the communication states. Therefore, because she does live with a registered sex offender and she's filing a lawsuit in the interest of Ivan and Ruben, but then lives with the sex offender. So no, I don't object to the admission of that exhibit. Objection. That's objectionable because nobody can verify whether that's a true statement or not. She's the only one that would know that, and there's no one ever to verify the fact that whether she does or does not leave them in his care. The fact that she lives with a registered sex offender and does not disclose that to the court, even though she's supposed to, as per the divorce decree, is just not correct at all. Objection. I don't use drugs, and she has no proof of anything of the sort, no evidence to prove it. And no one's ever seen me, or I don't even have a criminal record to begin with, never been arrested, I've never had any sort of affiliation with drugs to say that I am it's an allegation that's unsubstantiated. It's a defamation of character, and I don't see why we're talking about this if she can't prove it. Objection. That's not factual. That's not correct. She's not stating anything that she has firsthand knowledge of or has evidence of in any way. I don't see why this is relevant. And I did not get involved with any drug cartel. Objection. She has no. I did not get involved with a drug cartel. She doesn't have any evidence of any sort of drug affiliation. I don't even have a criminal record. Never been arrested. Never been anything. I don't have a criminal record. I don't see why we're talking about allegations that are unsubstantiated by any evidence. Objection. That's not factual. I never stated that. Objection. That's verifiable by her own paperwork, where she says that she wants to strip away all the ability and to be a father, and she wants supervised visits as if I were a criminal. That's something that you can see in her own paperwork. She's trying to do. That's not correct. Objection. What is the probable cause for any of that? What evidence does she have for any of that? Why do I have to subject my body for search and seizure under no actual evidence of any fact? She just stated she had no firsthand knowledge of any sort of drug use, so why should I, with no probable cause, submit to anything? That's a violation of my body and objection. She was also withholding my sons from me. In fact, I actually sent a formal notice where I talk about how she's been withholding my sons from me, and it's not factual what she's saying because she withheld them from me. I just didn't go through and call the cops on her that she did. Objection. She's supposed to pick up and I'm supposed to drop off. How is that relevant to whether or not we pick up or drop off? Because we're supposed to trade off that way. It's part of the decree. I just, like I said, I want to refer back to the fact that she sued me based on the, I mean, I object to the summary on the basis that she's got nothing to prove, she's got no evidence of anything that she's asking for, and it's kind of erroneous to prove a negative. How do you prove you're innocent? I'd like to ask her very specifically, does she have any firsthand knowledge or proof that I do drugs or am a drug addict, as she says, and am involved with the drug trade? It's a yes or no. Do you have firsthand knowledge that I'm involved in the drug trade, that I use drugs, or that I, in any way, shape, or form, am involved with criminal activity? Firsthand knowledge? No. Are any of the allegations you're making on your petition in regard to accusations of drug use or criminality on a firsthand knowledge basis? Do you have any first-hand knowledge at all in any way, shape, or form in regard to evidence that I'm involved with any kind of criminality? No. Are the allegations made in regard to criminality and a way of defaming or making me look bad so that you can get the petition on your side? So if you don't have any first-hand knowledge, how is it not to make someone look bad or defame them what you put as an allegation? I told you what exactly? I told you what?
You told me the reason why you forgot.
And that was that I was involved with criminality?
That you got caught up with someone that was involved in the drug.
Did I tell you that I was threatened by someone?
Yes.
Okay. Was it me being involved with them, or was them threatening me? So, in general, the allegations of criminality are unsubstantiated as far as we can understand. Yes or no? As far as all the allegations you make of criminality on my part, they're unsubstantiated. They're just simply allegations. Are they unsubstantiated with evidence, or are they allegations?
I don't have evidence.
You don't have any evidence. Do you have any first-hand knowledge that I'm involved with criminality on you witnessing me being a criminal? No. Okay. Is there any reason why you allege criminality without having first-hand knowledge on a court paper or a petition that's going to go and be submitted through the court?
Because you first-hand told me, and I want my
I told you what exactly?
that you were involved with people who were.
I'm sorry. We've asked and answered this. You said that I was threatened, and I told you I was threatened. I did not tell you that. Did I or did I not tell you that I was involved in criminality or that I was threatened?
You were involved with people that were involved in all that. So
I told you I was involved with criminality, or I told you I was being threatened. Which is it?
that you involved someone who had involvement with stuff.
So I told you that I was being threatened. I did not tell you that I was being involved in that criminal activity. Do I have a criminal record, Fonda?
I'm not sure. To my knowledge,
Okay. So I'm going to move on from this because there's no point to continuing this line of questioning. But does your stepfather, is he a registered sex offender? Does he visit the house regularly? Does he have a restraining order against your family members?
I don't know the details of my daughter.
You don't know the details of your stepdad?
No, I was 11 or 12 around that. I know the situation, but he does not live with us.
Does he go over routinely enough to visit your mom?
He comes and helps around the house.
Okay. So we can say that he's part of your daily lives?
No, he comes when he sees things around the house that he
does he have another residence that he's supposed to be at all times instead of being at your residence? Does he have a formal residence he's supposed to check in with? Okay. Does he still have a probation officer? So does he have a parole officer at this point? So can we say that you filed a lawsuit for in the interest of your children, yet the sex offender that goes and visits your house regularly, you don't have any idea what the deal is with that? But you don't know what's going on with him. So you filed a lawsuit for the interest of your children, yet you don't know what's going on with the sex offender that regularly visits your home. Is that? I'll rephrase the question if need be. Is it accurate to say that even though you're filing a lawsuit in the interest of Ivan and Ruben, you don't really have an idea of the full extent of the record of criminality that a child sex offender has that visits your house regularly? That's hearsay. Lastly, I'd like to just simply ask Rhonda Doe if, for the reason being for the fraudulent signature that's at the end of submitted evidence by Conker at the back of a divorce decree that he resubmitted, where my signature was forged on the last page of that submission of evidence. And also a notary seal stamp was forged as evidence of me giving up my parental rights or my parental. Well, you submitted the evidence. Well, I'll rephrase the question. If we're doing things in the interest of Ivan and Ruben, and everything that I've done in general, and even in the divorce decree, have been in the interest of Ivan and Ruben, how is it that she's saying now that I'm not doing things in the interest of my sons? So you're saying you're saying that I never helped you financially. Okay. Did I ever help you with your schedule while you were going to school as well? Picking up and dropping off Ivan and Ruben. Whenever it came time to either have and subject my sons to being driven for half an hour in the mornings or 45 minutes in the mornings just because I wanted to have them on a weekly basis. And it was closer for you to have them at that point. Did I not choose what was in the best interest of my sons and agreed to keep them with you, but at the same time help you financially when I did that? So, is it that I helped you financially or did I not help you financially? Which is it? During the time that I was helping you through your school and helping you drop off the kids to work around your school, and even when I decided that, at the moment it was, better for them to be 5 minutes away from their school versus 45 minutes away from their school, do you not call that me being there and present? Did you ever notify me of any kind of issues in a formal notice of any type at all, that you were having some sort of issue as per the divorce decree required? Was I ever notified of anything in a proper notice? Well, in the divorce decree it says that before any sort of litigation you're supposed to notice me of any sort of issue so that we can work it out. Did you ever do that formally? The divorce decree is before the court because the original court that issued it was this court. So it's under the same court. How can you object to it being issued there or at all being brought up? That's why we're here. It does. It very specifically mentions that a notice has to be given to the other party if any litigation is ensued against the other party as a form of indemnifying each other or protecting each other's back. It's also a way of making sure that me and her can co-parent through any kind of issues freely and openly, which she never did. I never received a formal notice that she was having any sort of issue before I was sued, in violation of the court order she signed and agreed upon. Yes, let me tell you, that would be in, it's I believe 27. Let me double check that. I don't have it pulled up, but I believe it's page 27. Or 20, 1 second. One second, I'm pulling it up now. I didn't have it pulled up before. I'm sorry, what? So, there, 1 second. Okay. There were several provisions in the decree that are supposed to protect both myself and her in order for us to co-parent freely and openly. And the protections are in the fact that we have to notice each other, or first, before any sort of litigation be ensued, let each other know what the issues are so we can freely and openly work through whatever issues are happening. And she has never abided by it. And it's a way of protecting not only one another, but it helps us co-parent. Give me 1 second, I'm working through it. I didn't have it pulled up in front of me. Just give me a second, I'll give you that provision. It's on page 21, and it's the second paragraph. It says, notice shall be given to the other party by delivery of registered certified mail, return receipt requested. No, that's not it. Okay, it's on page 28, and it's near the last two paragraphs. It says, the parties agree to, and it is ordered that each party will give the other party prompt written notice of any litigation threatened or instituted against either party that might constitute the basis of a claim for indemnity under this decree. Is she not suing for money at the moment? Correct, but right under that paragraph, it also says that it is ordered and decreed that all relief requested in the case not expressly granted is denied. And that is a final judgment. It also mentions that the judgment it finally deposes of all claims and parties and is appealable, yet she never appealed it. She also never went and, well, yeah, I want to know if she ever appealed it. Did she ever make a formal appeal? Did she ever make any formal notice to me that anything was amiss with her in regard to issues she was trying to work with? Written form. I'm sorry, the question is, did you ever make a notice, a proper notice, through the mail, through text, a formal notice, letting me know that you were having issues that we could work through together and let me know beforehand? Have you actively tried to communicate with me and genuinely sat there and spoke to me about things that are relevant to Ivan and Ruben instead of just trying to argue and fight? You have. In what instance did you ever also tell me that financially you were having issues and noticed me of that issue? And the one time that I remember it happening, I actually signed over the tax credit to you because you said you wanted more money. Did Rhonda Doe ever notice me of any issues that she was having so that we could work through it instead of just suing me, which is in contrary to the decree? Do you have any proof of said notices? So are they proper notices, or are they you sitting down or saying that we verbally sat down and talked about it but have no way of proving them? The relevance of the issue is specifically mainly I'm trying to show that I, at this point, am the one sitting at this end getting sued for the, whatever reason she decided to sue me for, but she hasn't communicated with me or actively sought for actual communication to fix any sort of issues. Rhonda, did you ever actively sit there and try to let me know beforehand what problems you were having so that we could work through it in a formal notice?
We sat down. What your question was, did we ever sit down and have a conversation? Yes, we have sat down and had a conversation.
No. My question is, did you ever send me a notice of the issues you were having so that we could work through them? The way that I've sent you notices in written form whenever I'm having an issue with whatever you're doing.
No, I have never sent it over.
Okay. Do you have any proof of the fact that you actually tried to work through do you have any sort of communications that you can prove that you actively try to work with me on stuff? Or any sort of proof that you tried to communicate with me in general?
Yeah, we've had multiple conversations.
Because you've submitted plenty of text messages I sent you, but you're not submitting any evidence that you sent me text messages in communication to anything.
Right, because every text message that you send me is like me with one thing after another. And
Right.
when we speak, I never get a chance to speak. It's always drop the lawsuit. And I never speak my part.
I threatened you of doing what?
When you threaten to bring this back up, like for example, with the refusal of the judge, my attorney, my stepdad, and all, that I saw your signature, is always one thing after another. And so I don't think that if you really wanted to work with me, that every time we speak, you would throw something like that out. That's not co-parenting. You don't listen to my side of the story. You don't listen to what me and the boys need. I came to you, and we've established that the boys have been living with me for many years. I tried to work out with you all those years, but you never worked with me, and I have to go through this route now. I don't want to do this, but I have to do it now for the boys.
At what point in time did I threaten you for any reason that you didn't do something like, use my information without my authorization for whatever reason, my social security number? Is that proper?
For the child support, when I had a conversation with you about child support, you told me go file,
No.
but I never went through with it.
Did you use my social security number and personal information for any reason without my authorization?
I went to the Office of Attorneys through the child support office website and put in the information that they asked for them.
So you used my personal information without my authorization, which I received mail from that office, and then I told you that you were committing identity theft because I never gave authorization. Is that what you're referring to when I say threaten you with a lawsuit?
I submitted what the website asked for child support.
Is that what you're referring to when you say that I threatened a lawsuit?
You told me I was going to go to jail for identity theft for putting your information that they asked.
It's a yes or no question. Is that what you're referring to when you say I threatened you with a lawsuit? Is for using my personal information? Okay. Did I ever threaten a lawsuit for any other reason than when I talked to you about either enforcement of the decree or any sort of you using my information without my authorization? Have I ever threatened you with any lawsuit aside from those two things?
Now you're saying that I saw your signature and that I was going to get in trouble for that. You told the boys that.
Like I said, have I ever threatened you with a lawsuit outside of the fact that I was either trying to enforce the decree or you used my information, personal information, without my authorization? No. So anytime I threatened a lawsuit was because you were acting outside the decree or because you were using my personal information. Is that correct? It's a yes or no question. Did I ever threaten a lawsuit outside of the fact that I was either trying to enforce the decree or you were using my personal information? No. Okay, so I never ever threatened you aside from those two things, correct? Just to reiterate? Okay. So we've established that I threatened only under enforcement or using my personal information. We've established that I don't have and you don't have any evidence of criminal activity of any sort or me being involved in anything. And we've also established that you didn't ever notice me of any issues formally in a written form the way that I have noticed you. Is that correct? Okay. Lastly, do you agree or disagree that from the get-go after the divorce, I acted in the way that would benefit not only yourself, but my sons, and by way of them also protect each other, and it was done so in the most fair way by giving you, joint custody and having the same rights I do? Okay, was it? Go ahead. So, did you ever in turn feel that I was doing something just to hurt you in anything that was formal and paperwork done for the courts and what I chose to do with my sons and yourself? Was I ever doing anything malicious in that way to you? In doing everything that I have done, have I ever acted maliciously to hurt you directly for some reason or another while using my kids to do so? Okay. In what way have I done so, even in the present? Did you ever give me notice of those things? Formally, written? Okay. So how was I supposed to know that you needed help financially or otherwise if you never gave me formal notice under the divorce decree as you were supposed to? Didn't you say that you had no way of communicating with me, and you said that you had no ability to communicate for a long period of time, while at the same time saying that I was the one that disappeared? So how is that a possibility if you say that you've actively tried to communicate? How do you say that I disappeared and you couldn't communicate, and at the same time you say that you actively communicate? Did you have any other numbers in which you communicated with me through, for instance, my dad's number, my sister's number, my aunt's number, my uncle's numbers? I mean, you have a complete record of my entire family, and you say you couldn't communicate with me? and at the same time you say that you co-parent with me, but you feel like you don't have to communicate with me through, you know what, scratch that question. Have I ever not answered your calls whenever you call or text?
You have. Yes, there's been a period of time when you got called.
For instance, whenever there's something going on that is kind of serious, like inclement weather, do I not, or do I check on you guys just to make sure you guys are good?
You did that once.
Have I ever just disregarded whenever there's something going on with you that needs assistance?
Yes, for the 2.5 years or so that you were gone, there were things that happened that you weren't involved and you didn't know, and I couldn't trust you.
Well, for instance, did I not offer to go and for instance, put the kids' bed together when you had issues doing that? Hello? I am gonna try. I don't know what happened. Am I able to be heard?
Yeah, you're back now. You froze up a little bit, but you're back now.
Okay. And I think I've made my point in regard to how she's saying that I was involved, but I wasn't. She's saying that she can communicate, but she couldn't. I think I've made my point in regard to the fact that she stated herself that I have always done what is best for my sons, and
He's not asking questions at this point.
I'm not. I'm finishing off my testimonial thing. You know, I just want to.
Okay, hold on. Let's get up. Do you have any more questions?
I don't have any further questions to her. She's pretty much clarified, you know, what the intention is behind.
You have 2 minutes and 59 seconds left, so that's 5 minutes better.
I want to very specifically end up with she's in the first hearing. She stated I have never done anything wrong to her or my sons. There's not been an instance of violence. There's not been any instance of actual proof of drug use or any sort of allegation that she substantiated being provable. She stated herself that I've always done things in the best interest of my sons and her. She stated that I have, for the most part, in general, always done what is correct. I don't see how this goes from her saying that I've done those things, yet at the same time she says and alleges all the things that she's alleging, and she has no way of proving at all in any way what she's alleging. I think it's very unjust for her to be going for visitation supervised as if I were a criminal. I don't think it's correct that she's going for a straight up lawsuit when she herself stated she hadn't properly noticed me, she hadn't let me know what was going on with her, and she didn't let me know what was going on in her personal life, which I don't get involved with actually. And in her petition, she mentions that I secret my kids from her, that I withhold them from her, and she mentions that I withdraw them from, or she alleges that they've been withdrawn from school by me or anything, and I've never done any of those things. So in general, her petition is mainly about defamation of character and trying to allege that I've done these things that I have never done and there's no proof of at all. I don't see why the petition is valid, because she at this point doesn't have any standing to say that I am this person that she's put on paper. That's why I say that this should be dismissed on the fact that none of the allegations that she substantiated, she's been able to prove, and she herself has proven the opposite of all her allegations. I simply just want to go back to spending time with my sons, being a private guy the way that I've always been, and overall just being able to teach my sons the things that a mother could never teach. And I'm not being sexist here, but you have to be a man to teach a boy how to be a man, and you have to be a woman to teach a girl how to be a woman. And I think that valuable time with my sons in that regard should not be penalized over the fact that she didn't communicate with me and she's alleging all these things that she cannot prove. In closing, I don't see why this lawsuit is fitting of what I've done in the past and she herself has alleged and not been able to prove, and what she's actually testified to in regard to what I actually do. I've taken the time to make sure that I don't have a criminal record. I've taken the time to make sure that my kids never see, things that I do that they may think that I do wrong or whatever. I take the time to morally guide my sons in a way that a man should guide himself, and I don't mess with other people so that I don't have issues like this. She's alleging that I'm a complete opposite of what I've actually done in my life, and I don't think it's correct to sue somebody for what their history and their motives have always been is in contrary to what she has alleged in her lawsuit. So that for those reasons and her own testimony, I say that I'd be happy just to go back to being a father to my sons the way I have been, and I mean that's the main point of this whole thing. Is I just want to go back to being with my sons. I want her to stop withholding it from me, and I have sent formal notices to her on that regard and submitted, the police reports that she, when she did that, and she hasn't ever rebutted it. It stands as fact that she's done those things. So I haven't acted in bad faith towards her, and for her to go through and allege all the things she's done and sue me for something that she can't prove is completely not an administration of justice. Have a good day.
But didn't you say anything about the signature?
I did. You overpulled it. Didn't hear me?